efforts. Over to you, ma'am.
Hi. Good morning, everybody. Am I audible?
Yes, ma'am, you're audible.
Okay. Okay. So, Akanksha, right? Thank you so much, Akanksha, for introducing me. And first of all, really a big thank to Mr. Dinesh Meena, whose endless efforts have made this event possible. So, really thankful to him also. And thankful to all the students who have joined this meeting, irrespective of Sunday, right? Akanksha, I would request you to enter the people who are waiting in the room because it's obstructing my screen also.
Okay, ma'am. Got it.
Yeah. Okay, so I would like to start with the constitutional law of India because I think the most of the students are from law background, right, Akanksha?
Yes, ma'am, that is right.
Yeah. So whenever we talk about the gender discrimination and the gender sensitization, these are the two terms which always boggling into our mind when we start talking about the legal aid services, right? As the law students, we all the law students and all the law scholars, they all are agree that this legal aid and legal services are the part of fundamental right, right? So this is our fundamental right to get a um, free and compulsory free legal aid services. Now the question arises that in actual the women or the children or irrespective of gender, that how many people are aware about those right? Because there is a huge number of people who are not at all aware that how to have the access to this fundamental right. My chair and my co-chair, they must be agree with me that people who are living in a downtrodden society, they are not even aware about the fundamental rights, right? So there come, I think, the this project Saksham will start working, right? So first and foremost important job for the project Saksham 3.0 team is to make people aware that there is some fundamental right which will surely help them to access their fundamental right, free and compulsory, free legal aid. Now coming to the second part, when we are going to the downtrodden section of the society, how much we are aware about the legal aid, right? So you all have studied, most of you have must studied about the Article 21 free and legal aid services, but how, when, and what would be the mechanism to be provided? I'm totally talking about the practicality of the Article 21. I have seen so many women, I have met so many women who are not at all aware about this free legal aid. Even the law students, they know that this is the fundamental right, but they do not know how they should go ahead with this, right? They qualify their law course and then they register themselves, and then they are roaming around in the district courts or in the lower court, that how to get a clientage, right? So as a volunteer from Saksham team, you all should have the data that okay, these are the students who have just qualified the law and now they are registered as an advocate in free legal aid, and they should get the client and client should get the advocate. Coming back again to the Constitution of India. Now, Article 14, 15, and 16. These are the three articles primarily which are talking about the equality, and Article 15 and 16 are the enabling article for Article 14, right? Now, when I say that, okay, we all are equal and right to equality and equal protection of law is given to all the citizens of India, irrespective of their religion, race, caste, creed, etc. But Again, the same question. I learned Article 14, but how can I apply Article 14? What is the applicability of Article 14? Is the Article 14 incomplete without Article 15 and 16? Right? So Article 15 is, can anyone tell me what is Article 15 and what is Article 16? I think we have all the students here, right, Akanksha? Right? So they all are law students. Most of them are law students, right? Right,
Yes, ma'am.
Akanksha? Yeah. So can I ask that why I'm saying that Article 15 and 16 are the enabling statute? And my second question is, what is the applicability of Article 14?
Ma'am,
You,
Article 14,
yes,
Article
beta.
15 provides, no, ma'am, Article 15 provides the right to equality, right to not to discrimination against the race, sex, and birth of place, and religion, and caste, and Article 16 is about, I'm forgetting something. I'm forgetting about Article.
Equality
I'm the first
in
year
public
girlfriend.
employment.
Okay, ma'am.
Yeah. So, okay, let's try to understand right from the Article 14. Okay, Article 14 is talking about equality, but equality to whom? Equality
Before law.
for the weaker section of the society, right? So for me, I'm not talking about the gender. I'm also talking about the discrimination on the basis of religion, on the basis of caste, on the basis of creed, and on the basis of place of birth. But since the topic for this session is only for women and children, so let's focus only on this gender. Now, Article 14 says, okay, provide equality. How it is applicable? How will it be implemented in the country? How it is implemented in the country? And the important question is how the Saksham team ensure application and implementation of Article 14. You all are going to be a volunteer for Saksham team, right? So have you thought about it, that how we will implement Article 14? What would be your mechanism, your technique, your methodology to implement and to ensure the implementation of Article 14 along with 15 and 16, right? You all must be agree that we cannot read Article 14 in isolation, है ना? Right? Because it includes Article 15 and 16 also, which are called enabling statutes. Yes, Tushant, can you tell me what would be your methodology as a volunteer? Ritu Sharma, anybody can answer?
Ma'am, Article 14 provides basically a rule of law, and article matlab everyone is equal before law, and on except president and governor at the time of their office, they cannot be held liable for the and cannot be be presented before the court, I think.
Good.
And we and it is the equality rule of law, law is supreme. It provides that everyone before law, मतलब मैम लॉ से बढ़कर कोई नहीं है। मैं इवन कोई भी हो मैम, और इसके लिए हमें एक अच्छे एडमिनिस्ट्रेशन एंड अच्छे उसकी जरूरत है, अच्छे तभी ये आर्टिकल 14 इम्प्लीमेंट हो सकता है। जब तक हम अवेयर नहीं है और अपने राइट्स के बारे में तो जब तक ये नहीं हो सकता।
Good. Bravo. See, Article 14 is talking about two things, right? You're absolutely correct. One is equality before law, and second is equal protection of law. Now,
we can add this.
Yes, please.
For enabling the Article 14, we can add 2-3 more things in this. Actually, we have to work on the ground level to enable this, and our approach should be down to top, not top to down approach.
Correct.
And for this, we have to also see that there is a equality among equal, नोट लाइक दैट कि अगर इक्वल नहीं है तो इक्वलिटी वर्क नहीं करेगी वहां पे। तो हमें इन
Very
टू
good.
थ्री अप्रोच पर वी हैव टू डू वर्क फॉर
Wonderful.
enabling the article 14 and 15 16.
Wonderful. Amazing. Very good.
That's why Article 15 also have affirmative action for women and children.
Correct. Absolutely correct. Absolutely correct. Now, there are two things, right? Equality before law and equal protection of law. Now, let's talk about equal protection of law on first, right? The reason is we are going to talk about this only through this project when till this December. Now, equal protection of law is given and enshrined in the constitutional law of India. But you all are aware that this equality is not the equality which is mentioned in the US Constitution. This is the equality which is based on Gandhian Gandhiwad Siddhant, Samanta ke saath samta ka adhikar, right? Equality with equity. Are you agree? Right. So the next question is how the people will be measured. Okay, this is the person, they are not aware about the right to equality, and these are the people, they must be given the right to equality. There come the word equity comes into the picture. Whenever we are providing equality, you were correct that equality among unequals is not justified. And whenever we are talking about gender in toto, then women and children, they are, and men, they all are not equals. They all are unequal. And when we talk about the implementation of equality, we have to take this into consideration that we are going to apply the equality among unequals. So it should be there equality with equity. Now, what is equity? What is equity? Who is going to answer? What is equity?
Ma'am, equity is the principle. Ma'am, equity is the principle in political science where two peoples of two different backgrounds who are not equal per se, like they have same amount of opportunity or same resources, like comparing a person with no books and a person with a personal library. So technically, they both are not on the same board. So the law will give one affirmative action, that is one extra step, so that he can also be on same page. Equity is to bring a stage where there is proper equality.
Good, good, good. Anybody else?
Ma'am, equality is a concept that emphasizes fairness and justice. This goes beyond equality, which simply means treating everyone the same. Equity recognizes that people have different starting point and may require different level of support to achieve equal outcome.
Correct. So when we clear this, that where I am going to implement and applicate and have the implementation of equality, I have to consider equity. So it means wherever the resources are required more, put more resources. Is it clear in very simple language? So equity says that to bring equality, if the resources are required more, then please provide more resources. Now, to whom we have to provide more resources? To the downtrodden section of the society. Rather than that, I would prefer to use the word weaker section of the society. And to the weaker section of the society, we have to provide the equity. Okay. So now women and children, most of the times, less noticed section of the society. Nowadays, all the girls, students and women, they are started talking about, no, men are also not safe. They also need the protection. Yes, I agree. But how many cases are there when women is false and fake? And how many cases are there when women is exploiting men? There are very few number. This is in very few number, right? Now, when I say that equality has to be given with equity, so Saksham team has to try to find out who require more needs. Do you think that all the women, see, if I talk about only Gurgaon wala section, so Gurgaon is also divided into 4 parts, and then you all have to divide. Okay, this part of the Gurgaon, let's talk about the golf course road, right? The most posh area of the Gurgaon. Do you think that in this area, the women and children, they are safe and they are aware about their rights and they are not prone to any crime? Absolutely not. They are more prone to crime. The reason is they are less aware, number one. Number two, because they have the more luxury items with them, so there are more chances to get into the crime and become a victim. And number three is, this is the section of the society who will never ever discuss with you that, okay, I am the victim. They will not come ahead. However, when we talk about the other section of the society, to whom we call the women and children from the downtrodden section of the society, they will come forward, they will tell you what is happening with them. Now they don't have access to advocate, they don't have resources, and they don't know the process. This is the different part of the story. But you will come to know the primary problem they are facing. They will immediately tell you, okay, this is the case, this is happening with you, what should I do and where should I do? Now, when we are going to implement this thing, this one article, among weaker section of the society, we have to divide again that this is the downtrodden weaker section of the society and this is the upper section of the society, which is weaker but not accepting it that they are weak. I'll tell you my personal experience. A woman is a professor, English professor. She's suffering. Her in-laws threw her out of the home after her husband died. Now, she is not aware that irrespective of salary, whatever she is earning, she has a right to get free and compulsory legal aid. And she's professor, English professor, living in Gurgaon. So, when we are going to ensure people that you have rights, then first try to understand to whom we need to counsel, to whom we need to provide the opportunity, and do they need it and how they need it. Now, this section of the society, like this professor, they don't need your consistent support. They just need awareness and that's all. Your job is done. Then they will pursue on their own. But on the other side, the downtrodden section of the society, you need to give them consistent support. Stepwise, provide them advocate, take a follow-up, and discuss and decide, okay, has it been done or not? Is it clear? Now, all the states, be it Rajasthan or Haryana or UP, these are the 3 states where we always talk about that women are facing the more challenges and the more problems. They are more victims, right? We have had a very pathetic examples whereby women is victim of rigorous crimes, be it Nirbhaya case or be it Dr. Wala case. There are multiple and number of cases. These 3 state students are going to join this project Saksham primarily. But the method and modus operandi for these 3 states has to be altogether different. How? These 3 states have a different literacy rate. Rajasthan, UP, and Haryana. All these 3 states have altogether different literacy rate when you compare it with Delhi literacy rate. So I would request the Saksham project team, organizing team, that they have to devise a strategy and methodology accordingly. Now, people staying in Delhi, they are more prone to crime, they are more aware, and the strategy should be different. People in Haryana, more prone to the crimes, but less aware. Modus operandi should be different. Same with the Rajasthan. Now, coming to the third segment of my session is that is something happening at international level also? The answer is yes. So, in 2015, United Nations has adopted 17 Sustainable Development Goals. These are the same Sustainable Development Goal which India earlier had, MDG, Mahatma Gandhi Development Goals. Now, these 17 Sustainable Development Goals are implemented only on those countries and accepted by only by those countries who are signatory of United Nations. India is one of them. And we also need to implement all these 17 Sustainable Development Goals. Now, I'm going to tell you that how Project Saksham 3.0 is going to contribute in one of the Sustainable Development Goal at national and international level. When I spoke with Dinesh regarding this, I insisted him, let's talk about Sustainable Development Goals also along with the national goal, so that we can mark our presence at international level in the United Nations also. Now we have to implement in India, we have to have the application of all these 17 goals in all across the country. And the Niti Aayog, you all must have heard about Niti Aayog. Niti Aayog is an organization who is responsible for the implementation of these Sustainable Development Goals. Niti Aayog is trying to implement these goals through NAC team. Now, NAC is making mandatory for the institutions, higher education institutions, to implement Sustainable Development Goals. Now, any education institution, how can they have implementation of Sustainable Development Goal? I'll just be talking about one Sustainable Development Goal, and that is Goal 5. Goal 5 is related to gender equality. So whatever this Saksham 3.0 team is going to do, that is gender equality. We are trying that in India, we are going to ensure by providing the resources, by awareing the people, by helping them, we are going to ensure that we have achieved goal 5, gender equality. Till date, we have had a wonderful work under this goal 5. Our literacy rate, women literacy rate is increased. The awareness programs are increased, right? Now, how the Saksham team will work on this Sustainable Development Goal 5. Number 1, please be aware about the goal. There are 165 indicators against all the goals. Please read those goals along with the indicators. You will come to know how to implement these goals. Then please, second part, read the statistics data that where India is standing while talking about achieving the goal 5. Number 3, how educational institutions are working onto them. I'll give one example that how we are in our university, we are doing. So in my institution, I'm chairperson of Gender Sensitization and Safety Committee. And whenever the new session begins, I take one session with all the students in all the programs. And I talk about gender sensitivity. This is the first basic ground from where the gender equality begins. Until and unless you are not sensitized, until and unless you don't have empathy for the weaker section of the society, how can you talk about Article 14, 15, and 16? How can you talk about the Project Saksham if you don't have that sensitivity in your heart? Now UGC has made a mandate that every educational institution have to have the one session for the youth regarding sensitization, regarding gender sensitization. So when I talk about gender, this for me this is exclusive term. It includes male, it includes female, it includes third gender, it includes everybody. Every human being is included within the term gender. So how me, how you, how we all can be sensitized towards the word gender? So students always give answer, okay, ma'am, there is a law. And I know that this is a crime, this is an offense. So I'm not doing it. So I'm sensitive. I'm sensitized towards the word, towards the any crime which has been committed, which can be committed against the gender. But no, law is not there to change your behavior. And all the offenses are always related to behavior. Law is there to regulate your behavior. Law always regulate the behavior and only regulate the behavior. How? We always stop at the green, at the red light. Why? Because there is a regulation. They are regularizing your behavior. Sometimes you do not know even that, okay, red light is there, and back up the mind, you are talking something else, you are listening is on, and your foot is there on the brake, and your vehicle stop. How? Regulation. Your behavior is regularized. So when you are talking about this weaker section of the society, you have to have utmost sensitivity. Likewise, you are not aware and you stopped your vehicle at the red light. This type of sensitivity is needed whenever we are talking about any crime or anything related to gender equality. Unless you do not have that behavior regulation, you cannot achieve any goal. For me, when I talk to the students, I think that to regularize the human behavior, upbringing is playing and contributing at most, right? I'm coming from the different background. I have seen that men was beating a woman. I've seen some pickpockets around me, right? And at the same time, I'm born with a silver spoon. I have never seen such behavior. But yes, sometimes when the door was closed, I heard some women were crying, right? Something happening at front, something happening at the back side of the door. So society is already made up. They all have learned this concept very clearly, that this is the section who is weaker and will remain weak. Now, how to enforce society to unlearn the things which they have learned from the ages? It's not possible. So that's why UGC has made it possible that, okay, let's talk about the youth. Isliye youth is involved in Saksham 3.0. Youth, they can unlearn whatever they have learned from this patriarchal society. Can we? I mean, can you? Me and sir, I can see one sir here, Prashansit P. Kishnani. Sir, we are agree that we all are from the patriarchal society and we have made up our mind, we have learned the things and we cannot unlearn those things. Even if me and sir and all my law, all the faculties and respected deans are sitting here, we have imprinted the things on our mind and our heart. But the youth, you all can unlearn the things and you can relearn few things. Let's have that conducive environment. Let's have that environment where everybody can get a chance to live. This is the foremost and very, very small thing. Jio or Jeene do. Now, for Jeene do, whatever is required, equality with equity and provide that. only after involving this wonderful project, Saksham 3.0, I realized that this is the third segment. I mean, first and second they have completed successfully. This is the third segment, and now when we are going to get recognized by the Niti Aayog, we are going to get recognized by United Nations. We are going to send this report to the United Nations also, that see, apart from the higher education institution, these are the 1,500 or 2,000 students, youth, who is working on achieving the Sustainable Development Goal 5. And this will bring us some bring proud to the nation, proud and pride for the nation. So with this note, I'm so thankful, grateful to the organizing team and to all the students who have volunteered for this Saksham 3.0, and wish you all the best. Let's rock. Let's start this and let's bring a change around us, but first within us. Thank you so much. Over to you, Akanksha.
Thank you so much, ma'am, for enlightening us all. We now have the pleasure of inviting our co-chair, Professor Dr. Smita Nizar ma'am. Smita ma'am is the Dean of School of Law, Galgottias University. Smita ma'am earned her PhD in Disability Studies from National Academy of Legal Studies and Research, Nalsar University, where she analyzed the legitimacy of selective abortion on the ground of disability. She is the author of The Contradiction in Disability Law, Selective Abortions and Rights. We are honored to have her today with us. Over to you, Smita ma'am.
Good morning to all. Thank you, Akamsha. Am I audible?
Yes, ma'am, you're audible.
We are all here with a great mission. We are talking about how to empower or how to affirm rights for a particular vulnerable group of people. It's about gender and children rights. When we hear about gender itself, we are now confused. What categories will be getting included in the gender? That itself give us a kind of reference that, okay, gender, referring to gender itself is very risky, because whether it's female, male, or the third gender, it's a problematic aspect of having that identity. Any identity of gender is becoming an issue now. So that's why there is a high need to address this issue immediately. And I think Saksham has a kind of a great scope to address this issue so that we can have a kind of resolution for these issues itself. Because this vulnerable group, both gender, means we are now taking women and children. I would like to stick to that gender category, women, and the next category is children. Otherwise, it's very confusing because, let us address one issue first so that we can go or expand to other categories or vulnerable groups as well. I would like to talk about gender, but gender rights in respect of disability rights. I would like to have my topic as gender rights, the twin track approach of UNCRPD. UNCRPD, the UN Convention on Rights of People with Disabilities, is a kind of very revolutionary law adopted by the UN to address or to affirm exclusive rights for people with disabilities. And people with disabilities, we know that they were suffering or they were having a kind of vulnerable experience of the social prejudice. So this social prejudice is reflected in all of our laws. You take any law, you can see the reference of reference of disability as disabled. Earlier it was handicapped for physical disability, and for mental disability, mentally retarded. So when you see the terms, the law is referring to refer a group of vulnerable. Disability is referred as disabled or retarded. That means that they do not have equal value. That's why the UNCRPD, I would like to refer as a revolutionary legal document or the universal law, because it brought a paradigm shift in the long persisting social prejudice in disability and against people with disabilities. People with disabilities were treated as, as objects of abandonment. If we examine the history of 16th and 17th century, we can see that during 16th centuries, particularly in Roman countries, Roman area, like, whenever a child with a disability is born, irrespective of gender, they were abandoned in thick forest so that, some animal will come and eat them. So they were sure to discard that kind of people. So 16th century story I'm telling. Then later, 17th, 18th century, 19th century, and the war and all those, World War first, everything got a kind of, realization that disability is part of life, because you may either acquire disability or you may born with disability. So it's part of human life. So the perception got changed. Instead of abandoning, let us do something else. So the next was like, something like, okay, let the state take care of it, or medical treatment. So there is a medical model on disability. According to this model, disability is a medical condition, so that it requires treatment. But can we have any medicine for any disability? You think about a physical disability, you think about a mental disability, think about an intellectual disability. Do we have any medicine for these disabilities? We can ask any medical doctor. I have a lot of medical friends with whom I challenge every day. Do you have any medicine for disability? No, disability is a human condition. In order to prevent secondary disability, we can have the medicines. If we get a fever, whether I am a person with a disability or not a person with a disability, anyone who gets a fever needs to have medicine. Some of my friends who are following natural life or natural lifestyle, they do not even have medicine for any fever or anything. They just follow some natural approach or therapies, and they get rid of all those diseases. So see the perception of the medical model of disability. Medical model is telling it's a medical condition, but we can tell that this medical condition is for everyone, not only for people with disabilities alone. Then later, particularly after this World War, it became the state's responsibility to take care of the people who acquire a disability. Because, of course, war resulted in many people with disabilities. So it became a responsibility for the state to have some institutions to abandon these kind of people. So state responsibility is not to take care of the welfare of people with disabilities. It's just to abandon them, dump them in an institution. Take every time whenever there is a kind of, pandemic kind of situation. Earlier also pandemic kind of situations where everywhere these institutions will be discarded, because these are the secondary people. We do not take care of them first. So this was the model of the third model. So the state responsibility model means the rehabilitation. Then came the social model. According to the social model, okay, it's not only the responsibility of the state, it's the entire society's responsibility to treat everyone as equal. So you just give equal space for people with disabilities as well. So these were the kind of perceptions persisted against people with disabilities. It's quite simple: abandonment or medical treatment or rehabilitation or charity. These were the perception we related for people with disabilities. But after at the beginning of this 21st century, like we are all like, we know that we are individuals. The individualism, the philosophy of individualism. I'm myself. So in order to recognize this individualism, we need the support of law. So that's why, you take all the UN special laws for women, children, refugees, and everyone, that categories are getting specified there because they are in a vulnerable situation. That's why a new law was framed for protecting or affirming equal rights for people with disabilities. That's what the UN Convention on Rights of People with Disabilities, which came into force in the year of 2008. India is a state party to this UN Convention, and India has both signed and ratified the convention. I hope all of you know the difference between signature and ratification. Signature means we are just like, a diplomatic approach. We are just becoming part of that, and we will not do anything to implement that concepts or the law. But when you ratify an international law, then you are under an obligation to bring those legal norms to your country. So India was one among the first countries to sign and ratify the UNCRPD, and we started all of a sudden in 2010 itself, we started the effort to make the new law implementing the new legal paradigm of disability. So the new disability paradigm is this: people with disabilities are equal on par with all others. But here, Shobnama was talking about Article 14. You are all responding to that question. What is Article 14? Equality. Equality among equals, equality among unequals. So the second part is what coming for people with disabilities. It is the equality for people with disabilities is equality among unequals. Got it? So, because this reads two aspects, the substantive aspect of disability and the adjunctive aspect of disability. So the substantive objective will just remain on paper. Article 14, all are equal in India. But what we have seen last week in Kolkata, a medical doctor was raped and killed. Can we tell that Article 14 is working in India? It's such a strong provision, Article 14, equality for all in India. And right to life, it's connected to right to life also. Right to life is not only for Indians, anyone who comes in India, anyone who visit India, that is the widest aspect of right to life and equality. But what happened to an Indian woman she was not a woman from a village or a rural area. She was well educated. She was in a very esteemed profession. That's what the status of Article 14 and equality in India. That's where we are talking about equality for women with disabilities. Now, I would like to specify women with disabilities, though we were talking about people with disabilities. Here is where UNCRPD has adopted a new approach. It's known as twin track approach. Have you ever heard this term, twin track? Anyone? Okay. Now, this is the new term. And this term, even though this is for the disability rights perspective, it is a very beneficial legal norm for every vulnerable group of people, particularly in a patriarchal country like India. Because, in India, even though when the constitutional framers, the Constituent Assembly was framing this Article 14 and, the reservation policies and all those, we thought that, okay, once in a while, like after a time, we will all be recognized for our individualism, for our citizenship and all those, but not on the basis of caste and all those. But now, we are categorized on the basis of religion, caste, category, backwardness, and so many categorization is there. So this equality is not going to come into a kind of complete reality anytime in India. That's the exact reason this vulnerable group of people requires a special focus or special attention to address their vulnerability through affirming rights, equal rights. That's the significance of UNCRPD, because according to UNCRPD disability paradigm, all are equal and the state is under a responsibility to address the vulnerability of these equals by taking twin track approach. We have two vulnerable groups of people, women and children. They are always vulnerable because nobody will allow them to be empowered. And I'm again and again taking last week's incident because, see the vulnerability. She's a woman and, she studied well. She cracked the entrance exam and got it into the medical education. And then she started practicing. Then she was brutally killed in her office place itself, in her workplace. You must be remembering Vishaga. Vishaga has made guidelines how she should be protected at her workplace. Nothing has worked. And we are living in the 21st century and we are telling that all are equals. Here is where the importance of the twin track approach as well. Twin track approach means that whenever a vulnerable person is facing discrimination on different grounds or different reasons, then the state should adopt the twin track approach. You address the main vulnerability. So whenever it comes to gender, women are always vulnerable due to the gender category. Female, okay, if you are a female, always you are vulnerable. You cannot walk on the street after 8 o'clock. You cannot walk at morning. You cannot travel alone. You cannot go anywhere. You cannot work anywhere. And it's very obvious. No male doctor was killed anywhere in India. Why? Is a man more stronger than a woman in physical aspect or mental aspect? No, her capacity, her or his capacity is not defined in that manner. It is about the social attitude. Only she's getting violated all the time. Why? It's because of the social attitude. The prejudicial social attitude is forcing the society or the members in the society to violate her without any concern for the law. That's where the UNCRPD is telling, if a vulnerable group of person is facing disability for multiple reasons, you address each reason. That's what the tin track approach. And in order to make it more clear, I will tell you a story of 200 years backstory. Okay. 200 years back means, and India was something like full of caste category, religion category, and all those. And Kerala was more not at all an exception. Kerala, now we have, I hail from Kerala, that's why I'm taking an example from Kerala. Not only that, it's a very good story, very classical story to tell. So Kerala has 100% literature, but you talk to anyone, everybody give importance for the caste categorization and all those, because it's connected with the political reason also. We need the caste categorization because of due to some political reasons as well. It's not getting fade away anytime. I'm talking about the perception among people of a state where 100% literature exists. So in such a state, some 200 years back, if I tell you exactly in 1803, so at this time, a woman called Nangeli. So during this time, a tax called breast tax was in prevalence. Have you ever heard about breast tax? You might have studied in your legal history and all those. So these kind of topics are there. So this was in 18th century. So this time, the women of backward category or backward sections were not allowed to cover their breasts with any cloth. Okay, so this was the condition. If they wanted to cover their breast, they had to pay tax. So backward category women means their financial resources will be very lesser. They will not be in a kind of better position to take care of their own daily life. They have to go for daily job and all those. So those kind of people, if they want to cover their breast, they wanted to pay tax. But Nangeli was so angry with this policy, and so she started covering her breast and walking in front of everyone. Okay, so the authorities of that time, the tax collectors and all those, it got reported to them, and they came to her house. So her husband came first in front of the house and told that, okay, we will give you the tax. Then she came. So she asked me, why should I give you tax? No, you are covering your breast. You came in front of us covering your breast. So you need to pay tax for that. So she told, see the power of the women. That's what I see in this story. She told, okay, please wait. I will get you the tax. She went inside her hut. It was a hut, not a big house and all those. So she went inside and she came outside with a plate and containing her breast on that plate. Can you imagine? She chopped her breast. This was the protest done by a woman in the year of 1803. This happened in 1803 when there was no law to protect women. When a woman was asked to pay tax, if the government is asking a woman to pay tax for covering her breast, can you imagine that? So at that time, a woman reacted in this manner. And she became a martyr. She died in front of them, giving them the tax in form of her breast itself. So see, here is where the twin track approach. See, she was a woman. So gender is female. The first reason for discrimination. The second reason, she was belonging to the backward caste. The second reason, the gender, the female gender, and then the caste, backward caste, and then the financial reason also. She was belonging to a very poor family. She was not having anyone else to support her except her husband, who was he was just a toddy handler, I think, who used to go to that palm trees and make those kind of liquid. That was his. Very poor people. So from these see the vulnerable aspects. Gender becoming a ground for discrimination. Okay, if you are a female, then you have to pay the tax to cover your tax. Quite simple. Okay, see the attitude of the government itself. Then, okay, you are belonging to, in addition to that, you are belonging to a backward caste. Okay, you are not at all allowed to cover your breast. Then you do not have any financial capacity, so that you have to pay the tax. So this is, see the multiple ground of discrimination there. So whenever these multiple kind of discriminations are there, the government should adopt a twin track approach. So you make policies to address the vulnerability for gender status. You make policies and programs to address the second one, backward caste. Okay, you empower them, bring them to the equal status with all others. And then the financial capacity. So, you address all these issues. This is what twin track approach. In fact, for people with disabilities or even if we take it as women with disabilities as the vulnerable category, then this should be the approach. Because women with disabilities means, okay, you are a woman, then already the vulnerability or the discrimination is available. And then in addition to that, gender status of female, you are with a person with a disability as well. And person with disabilities are always discriminated because we do not even treat them as equal human beings. We treat them as lesser human beings. So the next ground, okay, if you are a person with a disability, then you do not have any capacity to do education, to get a job. You are completely incapable. Got it? So, discriminatory reasons are getting added by the society, not by the person with a disability. They are equal on par with all others. If they get equal opportunities, they will also perform like anyone else. So this realization or recognition is what the responsibility of the state. So you make that kind of policies and programs to affirm equal rights, addressing all these discriminatory rights. So for that, you need a twin track approach. So I will just praise UNCRPD like anything, because UNCRPD was the first universal law which brought these kind of legal norms for equality. In UNCRPD, we can see this was the strategy adopted by the UNCRPD, having a special provision for vulnerable group of people, and then mentioning about their rights in each provisions. For instance, Article 6 of the UNCRPD may affirm equal rights for women with disabilities. If you just refer UNCRPD, you can see Article 6, it talks about women with disabilities. Article 7 is talking about children with disabilities. Children with disabilities also the same case, because I told you, whenever we have the UNCR, sorry, we have the diagnostic test, like pre-diagnostic text will be there. So in order to know whether the prospective baby is a baby with a disability or not, and abortion laws permit abortion for prospective child with disabilities. So that's a status of the law to recognize or unrecognize people with disabilities as human beings. So in such a state, we have to recognize this twin track approach for people with disabilities. That requires a kind of recognition among ourselves. Because we should start talking about, see, people with disabilities are equal on par with all others. And they cannot be secluded from anywhere. It is our responsibility. First, it is individual responsibility, I argue. Because, if I am casting this responsibility on the state alone, this will not happen ever. Because this social prejudice is ingrained in us. Whenever I'm telling you, many of you, 99% of you might have thought why Dr. Smita is talking about this law, which is permitting abortion on the basis of disability. That's my research area. That's like stressing that on that point. So, we have a law, all of your law students. So, the Abortion Act and the PND, the Prenatal Diagnostic Techniques Act also tells that the disability can be diagnosed before birth, and if there is any disability, that baby can be terminated. Both laws permitted. That means that, their right to life is not recognized prior to their birth itself. That much we are ingrained in the prejudice against people with disabilities. We do not want that kind of lives. We treat life with disability as undesired life itself. That's why we have those kind of laws. In that premise, we should understand the importance of this twin track approach. Like you cannot get rid of putting a section in your constitution or the specific law. After UNCRPD, like we have the new disability law, the 2016 Personal Disabilities Law is there. In that law, Section 4 is mentioning about women and children with disabilities. And Section 9 is mentioning about home and family right to home and family. And Section 10 is mentioning about reproductive rights. In the UNCRPD, the same manner, Article 6 is mentioning about women with disabilities. Article 7 is mentioning about children with disabilities. And everywhere else, in all other rights, you can see the application of general rights to women in a specific manner. For instance, home and family. Home and family means it's for male and female, not only for female. But whenever a child is born with a disability, if it's a girl, it's a baby girl, then baby girl, it's a baby, birth of a baby girl is not a happy aspect for many of the Indian families, majority of the Indian families. Indian families always prefer sons. We are quite patriarchal families. So, there, if a girl is getting born with a disability, you can just imagine. Already a female baby and then disability also. And abandonment happens in a larger manner in India for girls with disabilities. They are getting abandoned. So that's where this twin track approach, if you are adopting this twin track approach and applying it in every aspect of life of females and children, then they will get affirmed with equal rights. And these kind of practices can be reduced. But like I'm talking about state responsibility, but it's going to take a lot of time. It requires force from us. It requires a sensitization at our part first. Okay, people with disabilities, are they equal on par with me? We should think about it. And sometimes we may be very sympathetic with them. They do not want any sympathy. I have a lot of people with disabilities as my friends. So I interacted with them in a very continuous manner. Then I realized my perception is wrong. They do not want any sympathy. They just wanted in equal treatment. You treat them as equal. At the same time, see the twin track approach, because like treating them as equal doesn't mean that I do not want to do anything for them. I am under a responsibility to do a lot of things with them, because this world has been we constructed this society without acknowledging their presence. For instance, take buildings. In our buildings, consisting of some 5 and 6 floors, there may not be a lift available. So a wheelchair use, if I have a friend with friend as a wheelchair user, he or she may need ramps or lift to reach the 4th or 5th floor of the building. So now I haven't cared about it, because I was thinking I can walk 5th floor or till 10th floor. So I did not acknowledge the presence of my friends with disabilities. So the first responsibility comes from me. Understanding disability is my responsibility first. And if you are in a classroom, let us see how many of your friends are there with disability. Not a lot, maybe 1 or 2. So giving reasonable accommodation to 1 or 2 is not a big task for us. So when Amartya Sen was writing his book of justice, he in one of his chapters, we can see his reference or a kind of argument that people with disabilities always requires additional resource allocation. For instance, I was talking about ramps and lifts in a building to give accessibility for people with disabilities. We did not construct a lift or ramps at the beginning plan of the building construction, because I was never ever thinking about people with disabilities. I was thinking about myself and we are all very perfect. We are all very capable people. We can just walk to the 5th floor or 10th floor. So I was thinking myself was a very capable, and I forgot about my friend with disability. That's what happened. I did not acknowledge them. And now, if I was in an acknowledgement style, I would have constructed the steps or the ramps or the lift at the beginning itself. There was no need to allocate this additional resource. This additional resource aspect is coming because of my fault. I forgot them. I forgot to accommodate them. So there is a need for this additional resource now. So, accessibility is a kind of mandatory rule now. So building permission will be given only after you make all those accessibility. So, I cannot agree with Amartya Sen's argument about, this additional allocation of resource, because additional allocation of resource occurred because of my fault, not because of the people with disabilities fault. I did not consider them. I forgot the social justice aspect. Even as a law person, I forgot the social justice aspect. Here is where I would like to tell my students, or all of you who are going to become part of this project, that this project is not a 1 or 2 days project. It's a long project. It will be sustaining till we achieve the result. So we should understand that how we should plan accommodating people with disabilities in everything. That's where this twin track approach does matter for the accommodation and affirmation of the rights of people with disabilities. And I may be taking 2 or 3 more minutes and then I'm winding up. So we were talking about this twin track approach, particularly for gender aspect. I told you, because women rights are always in I will tell it's in peril, because we are not at all safe, because nobody is treating us equal. That's for sure. Okay, if you walk at 10 o'clock, your equality is gone. How can you walk at 10 o'clock? That is what the social thinking. That's what the people think. If somebody is getting raped, people will ask, okay, why did she wear a dress like that? Nobody cares if a male is just wearing just a trouser. Nobody cares about it. Nobody complains about it. So, and if something happens to women, the fault is on her. So no, UNCRPD is telling no. You take the twin track approach because she is already vulnerable because of the gender aspect. And the second ground is disability. So she is becoming, you are framing more vulnerability for her. It is not her fault. It's your fault that you constructed more vulnerability on her. So you do more for her. Literally speaking, twin track approach is something like you do more for her systematically. You address each thing. That's what twin track approach. And this approach can be viewed from one more case, Sujita Srivastava's case. Have you heard about this case, Sujita Srivastava's case? It happened in 2008 or 9. Sujita Srivastava is a lady with mental disability. Means she's not so-called mental retarded and all this. She's a very sensible girl, okay? But she was abandoned by her family as she was a baby with a disability, girl child with a disability. She was abandoned and she was taken care of by a government institution in Chhattisgarh. And from there, and her mental age was just 7 years old when she was 18-year-old. So she was a person with mental disability or including intellectual disability. So they have mental age and physical age also. The physical age was 18 years, but the mental age was 7 or 8 years. So she was sexually abused by a security of that institution, that government institution, and she was impregnated. And she was not aware about it because her mental age was 8 years old. So she was not aware about that she was carrying a baby. So then one of the maid noticed that something is wrong with the girl. So they took her to the hospital and then it was diagnosed that she was carrying a baby. So then see the immediate response. Whatever may be the reason for a pregnancy, whether it's a rape, a gang rape, or a kind of living in relationship or an affair or a marriage, anything, you will think about the pregnancy, about the first is about it's the women aspect. Okay, I will decide about my pregnancy. If I consider my reproductive autonomy, it's my decision. I will take decision about my pregnancy. But when it comes to the pregnancy of a woman, it's different. Take another example. I was telling about ourselves. I will take decision for my reproductive autonomy. And if it's a person with, take another example, rape victim. For rape victims also, the victim will take the decision, not anyone else. Victim will tell, okay, she may be talking to her parents or friends or something like that. It's the decision of the victim, whether she needs the baby or not. That's the aspect. The autonomy is getting exercised in some manner in all those cases. But when it comes to a woman with a disability, no, you cannot take decision for anything, particularly on your reproductive autonomy, because you are not a person with a legal capacity. You cannot take that decision for yourself. You cannot take decision for your body. So someone else will take the decision. That's what happened in Sujita's case. Sujita was already an inmate of a government institution. So immediately the government filed a petition that because the permitted time was over for the abortion. So the government itself filed a petition for the permission for abortion. And in Punjab High Court, I remember. So, I'm sorry, if it is wrong, okay, before many time I referred the court name and all this. So the case was filed and the High Court has given permission on the ground that she cannot take decision about her pregnancy as she is a person with mental disability or intellectual disability. So the High Court has taken decision, parents patria aspect, okay, government has all the reason to take this case. So we are permitting her. But someone else challenged it, a journalist challenged it before the Supreme Court. And the Supreme Court has appointed a doctoral committee. And to the doctoral committee, Sujata Srivastava, it's an anonymous name. So she told, remember, she was an abandoned girl. She was abandoned from the family when she was a child. And she was growing up in a government institution. We know what's the status of a government institution in India. It's not a 5-star hotel. It's so pathetic if you visit any institution, whether it's a private orphanage, private institution, or a public orphanage or public institution, you can see the pathetic lives there. So that's where she was living. So that she reported to these doctors that I'm going to get a company to play. This is what she mentioned to the doctors. Even though she was a girl of 18 years with her physical capacity, she was just a 80 or a girl with her mental capacity. So she told that I'm going to get a company for my life. This is what she told. And luckily the doctors mentioned this. Okay, so I need to give birth to this baby. So she considered her as a toy. She considered her baby as a toy for her, or a company for her. So I don't know. I consider it as very fortunately, Supreme Court has considered the reproductive autonomy of that woman. So immediately after seeing this report, the court has changed its perspective. Interpretation perspective got changed. Okay, the girl is telling she's going to get somebody. Okay, my reproductive autonomy can be interpreted in that manner also. Even for a gang rape or a rape or anything, the woman can take a decision. Okay, this is a new human being. I can have this baby. So it's my reason. My reason should be applied in my reproductive autonomy decision. This is what happened in Sujida's case in the Supreme Court. So Supreme Court said, okay, let her give birth to the baby and let the state provide her with all the required support. This was the judgment. So that she was given birth to a baby girl, and she was adopted by an organization in Bangalore. Now she's in Bangalore, and the baby also grown up. She's doing her schooling. And you cannot even believe the changes happened to Sujita. Sujita is a perfect mother now. She she makes the baby get ready for the schooling. She pin the hair and every day making ready the girl for the schooling and all this. And we were surprised to see that the changes happened to Sujita, and she was very alone without anyone. And when she got a company in her life, she became a perfect mother than any perfect mother without disability. This is a change occurred in her life just because of judiciary's permission. Okay, you give birth to your baby. That's all. This is what the reproductive autonomy for women with disabilities. And at the same time, you see there are a lot of issues in that institution, that government institution. There was no safety. Just like our last week incident, she was raped actually silently. She didn't know she was getting raped. So these kind of aspects are all getting involved in these issues, very critical legal issues. This is what we should understand. When we understand, when law students understand these aspects, you will start talking about this. You will start writing about this so that, others will start talking about it. Others are very ordinary beings. They do not know. They will never think about people with disabilities are equal human beings. Law students, a law person can only treat people with disabilities as equal human beings as first. Law is the strongest tool anytime. Law can change anything. That's the reason I challenge this PNDTI, prenatal diagnostic techniques, which tells that, okay, you diagnose disability, and the medical termination of permanent MTP Act is telling, okay, you abort prospective child with disabilities. I challenge these laws in my research and in my book. That's what my research was. I'm challenging the law itself, because when the law is discriminating people with disabilities, equality will never happen to them. Equality cannot be affirmed for them at all. So law should change first. The law perspective should get changed, because we have new legal norms, like the strong legal norms such as TINTRAC legal norm, reasonable accommodation, accessibility, and all these are there. So just get all those aspects. So you see, TINTRAC approach, you have everything: reasonable accommodation, you have accessibility norms, you have adaptability norm, many are there. So you add all these legal norms to establish TINTRAC approach, so that multiple discrimination reasons can be combated in that manner. We need to adopt those kind of strategies, and I hope with these things, like we can have a kind of new view for the law itself. And this TINTRAC can be applied to any woman, not only for people with disabilities. Any women. I was telling Nangeli's example that many women are facing even now. Even though it happened, Nangeli's story happened in 1803, but even now it's happening. Women are discriminated on the basis of caste also. We can see that religion also. All those are there. That's why I'm telling TINTRAC approach has a kind of, very crucial legal relevance now, which everyone should, get take it as a kind of new norm to be promoted. Let us talk about it. Even in a classroom, we can talk about it. If a student, for instance, I'm getting, I'm just an acting dean. Okay, so Agamsha was introducing me as the dean. I'm just an acting in charge dean, because our dean our Naresh Kumar, Professor Naresh Kumar from RGNLI was the dean here. So he had to just leave immediately. So I'm just in charge till a new dean is coming. So now, in administrative position, it's something like, I'm getting in a lot of medical applications from my students. Okay. They're telling I'm in a medical condition, please give exemption from attending the class and all this. So I was like, my God, what can be done? One, I cannot discard my students. I have to give some support to them. And the next one, they will lose the classes and they cannot write the exams. So, all these things. So, I'm thinking, my God, how many reasons, how many things, how will I address? I should be very fair enough. So I started sending these medical documents to my friend doctor and my brother also. So, they are examining the medical documents, telling me, see, this medical condition needs your support. This condition doesn't require any support from you. So, this is what I'm getting. So, you see, like it's all about individual approach and collective approach. You individually address these kind of multiple reasons of discrimination, and in order to address those multiple discrimination, you need a collective approach. You may not be enough. You alone may not be enough for that. That's the reason I was telling in between, state responsibility cannot be taken as the whole aspect of twin track approach and its establishment. We can have it in the individual responsibility as well. Let me try from my side first. Let you try from your side. Let your friends try from their side. So, one by one, then it will be forcing the government to get fall to us in that line, because all of us are there. So that's what Tintrak approach. And if we can happily get into this approach, and it's not limited to one gender or one condition. It's for everyone. It's a kind of very exhaustive approach. So it will make a kind of it will open the doors of law to affirm equal rights for everyone. That's why this gender rights and the Tintrack approach for UNCRPD should get more attention to make that kind of policies and programs for affirm equal rights for gender, particularly for women with disabilities and children with disabilities. And with this, I would like to wind up my talk. And if any one of you having any kind of queries or anything, we can have that also if Agamsha is having time to give us for that. Thank you all. And I would like to thank Parameshwari Ma'am and Agamsha and all the Saksham group of members. And I would like to thank my co-speakers and co-chairs and everyone. Thank you so much for this opportunity. Have a nice time to all of you.
Thank you so much, ma'am, for sharing your invaluable insights with us. We now have the pleasure of inviting our next guest professor, Dr. Namita Jain. Professor Namita ma'am is HOD of School of Law at JCERC University, Jaipur. Ma'am has academic and administrative experience for more than 14 years. Currently, she is working as HOD and Associate Professor, School of Law, JCERC University, Jaipur. She was member secretary in a committee constituted in pursuance of the government of Rajasthan. She was also a nodal officer for Unnat Bharat Abhiyan, a national program launched by MHRD, Government of India, and a member of various other academic and administrative committees. Ma'am has been awarded various awards and recognitions. Her leadership and commitment to justice are invaluable to our cause. Over to you, ma'am.
Thank you, Akansha.
The committee called the HEMA Committee.
Is it is audible, Akansha?
How women in
Yes,
minority industry are treated and how rampant sexual harassment is. Welcome to a special edition of Let Me Explain. This one co-hosted by Dhanya Rajan. In this episode, we look at why the HEMA Committee was formed, 5 important takeaways from the report, and the concerns that we have with the report and why it's sort of an incomplete exercise. So it's common knowledge that film industries across India are patriarchal and let's say not the most friendly or healthy environment for women to work in. Why did Kerala government specifically start with HEMA Committee report? So before I answer that question, Pooja, I just want to tell our viewers that the News Minute has been following an incident which happened in 2017, which led to the formation of the HEMA Committee, and all that has transpired over the years very seriously. because we take reporting on gender issues very seriously. And every week, either me, Pooja, or our other colleagues come and tell you that our reporting, if you believe in it, please do become subscriber. I'm sure you either listen to it or you just skip it. That's पास के सोना गाची से सोल का स्टोरीज के अंदर लेके आते हैं really matter. कुछ लोगों की फोटो आई बाहर जिनके लिंक टीएमसी से निकले ये पूरे हॉस्पिटल में अपना शिकार ढूंढता है देखिए जो कोलकाता केस हुआ है इसकी वजह से पूरे देश में बहुत ज्यादा गुस्सा है 24 घंटे के अंदर एक्यूज जो था उसको भी पकड़ लिया गया सीबीआई को भी केस ट्रांसफर कर दिया गया लेकिन ऐसी क्या चीजें सामने आ गई जिसकी वजह से लोग अभी भी प्रोटेस्ट कर रहे हैं और ऐसी क्या सिचुएशन वहां पे बनी हुई है कि अथॉरिटी ने साफ कह दिया कि हमने एक्यूज जो है उसको पकड़ लिया है तो फिर लोग इसको गैंग से क्यों जोड़े तो देखिए जो पूरा केस है ये जितना सिंपल लग रहा है उतना है नहीं इस वीडियो के अंदर मैंने कोशिश की है कि जो एक्चुअल रूट कॉज है वो आपको समझ में आए ताकि आप अपना ओपिनियन बना सकें अभी आगे वीडियो
So, you have seen the short clipping of 2 videos and understood that after 11 years of enactment of Prevention of Sexual Harassment Act of Women, Sexual Harassment of Women at Workplace, Sexual Harassment Act, women are still not safe at workplace. As you all are a student volunteer of Project Saksham, which work for legal awareness and legal aid. So it's your duty to work. It is very essential for you all. You must aware of this act and what is the act is for. Let's discuss. For protecting the women from offenses, first initiative is taken at the global level by the United Nations by adopting a convention on the elimination of all form of discrimination against women in the year 1979. After 17 years, that is from 1979, after 17 years, that is in the year 1993, India ratified this convention. What happened in the country that after 17 years, India decided to be a part of this convention? Yes, in 1992, a significant incident of workplace sexual harassment occurred in Rajasthan, India, involving Bhavri Devi, a social worker who was gang raped while attempting to prevent a child marriage. This case brought national and international attention to the issue of sexual harassment in India and highlighted the lack of legal protection for women. In response, the Vishakha guidelines was established by the Supreme Court of India in 1997 to address workplace sexual harassment, marking a crucial step towards safeguarding women's rights. It's ironic that despite the outcry following the Bhavri Devi case in 1992, and the establishment of Vishakha guidelines in 1997, it took the Indian legislature another 16 years. See, after 17 years, India ratified the convention, and after 16 years, legislation enacted the Prevention of Sexual Harassment of Women at Workplace in 2013. This delay, along with recent incident, underscore how little attention has been given to ensuring the safety of women in the workplace. Now, it is essential to know what is sexual harassment. Sexual harassment includes physical contact and advances. Means anyone, if with wrong intention, touches any female, then it comes in the category of sexual harassment. Demand or request for sexual favor means come to my office at this time, I will promote you, or if you will not come, I will demote you. Okay. Making sexually colored remarks, showing pornography, and any other unwelcome physical, verbal, or non-verbal conduct of sexual nature. Now, it is very essential to know what is aggrieved women. Okay? Aggrieved women may be working in the organization itself. maybe she is a visitor of that working place or student. Come to the point. What we include in working category? She may be a domestic worker. She may be a regular, temporary, ad hoc or daily wager. She may be for remuneration or for voluntary basis. She may be employed directly or through an agent, or she may be contract worker, probationer, trainee, apprentice, called by any other such name. So as you all are a student, you must know that student also come under the category of agri women. Secondly, if you are going for any internships and such kind of act is committed with you, then also you come under the category of aggrieved women, right? Now, next, what is workplace? What we include in the category of workplace? Workplace may be a public sector, means regulated and controlled by the government, may be private sector, hospital or nursing homes, any sport institute, stadium, sport complex, or competition or games venue. Means if at present Paralympics is take place in Paris, if something is happened there, then it also come under the category of sexual harassment at workplace. Okay? Any place visited by the employee during employment, including transportation provided by the employer. Means if suppose if this program is not in online form and it is in offline form, and through a car which is provided by Saksham team, I come there or any incident of sexual harassment is taken place with me, then it comes under the category of sexual harassment. And next, dwelling house or a residing house. What kind of employees covered under the POSH? As I discussed earlier, it may be a regular employee, temporary, ad hoc, or on daily wages, person working on voluntary basis, or includes contract worker, probationer, and trainee. Now, what is the redressal mechanism is available in a POSH Act? So, it is the duty of the employer to create a complaint committee. Means there are two types of committee which acts provide for. One is internal complaint committee and other one is local complaint committee. Okay? For organized sector, every organization institute have a mandatory duty to constitute internal complaint committee. And for an unorganized sector, means where there is less than 10 employees, then it is duty of district to constitute local complaint committee. Now, ICC is a main committee which is established in all organizing sectors which are organized. How is the composition of this committee? Internal complaint committee consists of a presiding officer, not less than 2 members from among his employee, at least 1 member from non-government organization, means NGO, and one condition is that at least half of the members are women, right? Now, what are the objective of ICC? Basically, the objective of ICC is to formulate anti-sexual harassment policy for the organization, provide a mechanism for the prevention of redressal of sexual harassment, and to raise awareness, especially to raise awareness about sexual harassment and its various forms in the organization. As I discussed earlier, what is local complaint committee? It's a duty of district to constitute a local complaint committee, and it is constituted for all those organization, unorganized organization where the number of worker is less than 10, and all the complaints in which the employer is the accused for sexual harassment, then that complaint goes to LCC, not to ICC of the organization. The reason behind is that as the ICC is constituted by the employer himself and all the members definitely have influence of the employer. So decision always come in favor of employer. That's why if the complaint is against the employer, then it will go to the local complaint committee. Now, what is the procedure or what is the complaint procedure? Any women must file a complaint within 3 months of the date of the incident. Why 3 months? Because it takes time to decide whether I go for or not. If I share the data of regarding this complaint, out of 5, only 1 woman can file complaint for this harassment. So therefore, Act provide the time of 3 months so that she can complain for the offense which is committed against her. Next, the inquiry must be completed within a period of 90 days, right? Or in case of complaint, complainant is a domestic worker, then the matter goes to the local complaint committee, and local complaint committee transfer the matter to the police, and relevant provisions of IPC will be initiated against the accused offender. What is the procedure? If the IC, Internal Complaint Committee, find that the allegations to be true, it submits the report to the employer, and employer may take actions according to the act of the according to the provisions of the act, and the employer must act on this recommendation within 60 days. Now, what is the inquiry procedure? When a complaint is received to ICC, within 7 days, it's ICC send this complaint to the respondent. The respondent needs to respond to the complaint within 10 days. If conciliation is not attempted, the IC or LC initiative inquiry and investigation. During all this this whole process, ICC or LCC is treated or equivalent to the civil court, right? So basically, we can say from the day complaint is received, ICC or LCC have to complete the procedure of inquiry within 90 days. What are the action taken by the ICC during the pendency of inquiry? This is most important because it is very difficult for the women to face that person who did such act with her. So what are the action during pendency? Transfer, it is the duty of the employer, or ICC will recommend to the employer, transfer the aggrieved individual or the respondent to any other workplace, grant leave to the aggrieved individual up to a period of 3 months. Why 3 months? Why 3 months? Because it is the duty or it is mandatory for ICC to complete the whole procedure within 90 days. Okay? Or grant any other relief to the aggrieved individual as may be prescribed under applicable law. The employer may restrain the respondent from reporting on the work performance of the aggrieved individual or writing his or her confidential report and assign the same to another officer. This is most important. Suppose मैं aggrieved हूँ और मेरी कॉन्फिडेंशियल रिपोर्ट और मेरा अप्रेजल उसी को करना है जिसने ऑफेंस कमिट किया, तो पॉसिबल ही नहीं है कि मेरे फेवर में कोई बात होनी है. तो इट इज इंपॉर्टेंट कि restrain the respondent from writing his or her confidential report or any other work which is beneficial for the female. One important thing, because leave is the great issues for the for all workers. So here Act provide that the leave granted to the aggrieved women shall be in addition to the leave he or she is otherwise entitled to, right? This is one of the I think one of the most important section of this POSH Act, which says men too. Conciliation process, right? in conciliation process, first and foremost thing, no monetary settlement can be done. Okay, women cannot ask for give me this amount of money or I will take the complaint. Okay, so conciliation process is conciliation is allowed, but if conciliation is taken by the parties, then it is final. It will not again go to the IC, or no monetary benefit taken or benefit can be taken by the women. What happened in case of false complaint? If it is found that the complaint is malicious, women know the fact that the complaint is false, or she has produced any false or misleading document, then internal complaint committee recommend action against aggrieved against aggrieved against women's too, for the benefit or for the better, for preventing protecting that men also. Next, what is the employer responsibility to prohibit sexual harassment? Organize workshop and awareness program, must ensure a safe environment, create a policy prohibiting sexual harassment, display the sexual harassment policy in conspicuous place like the notice board. And again, as I said earlier, out of 5, only one woman file a complaint against a respondent. So in case if female is not found herself to file a complaint, then in such a case, she may took the help of She-Box. Okay, She-Box basically a single window access to every woman to facilitate the registration of complaint related to sexual harassment, irrespective of work status. So this is also one platform where she can file a complaint for sexual harassment. So this is all about what sexual harassment, prevention of sexual harassment of women at workplace said. But I want to say something on POSH, that in the whole act, there is no punishment is provided for sexual harassment. ICC is 100% constituted by the employer. So, in most of the cases, harassment cases are not registered or come to the ICC, because women know nothing will be happened, as all are the worker of employee, all have the influence of employer. That's why no action can be taken against that person who commit sexual harassment. So there is a need to make amendment in this act also. I think there is need of deterrent policy of punishment, deterrent theory of punishment. There is no need of preventive theory of punishment. We see many offenses, or in our daily life, we see the matter of rape, murder of women, sexual harassment of women, but no action will be taken because there is no dar in the accused. We talk about preventive theory, we talk about rehabilitation, we talk about reformation, but I think time came, eye for eye, tooth for tooth. The no cases of rape happen in India if the system of Hyderabad is followed in the whole country. The grievance, the gravity of the offense is increasing day by day, but the level of punishment, judgments are coming very late. So last, I want to say, when there is delay in judgment, there is delay in justice, then there is no need of that kind of justice. We see in the case of Nirbhaya, the main accused is acquitted on the ground of minority. Please see his video on the net. What he say? If in simple terms she allowed us to rape her, we will not do such a grievous act with her. ऐसा होना चाहिए और हम ऐसे पर्सन को हमने छोड़ दिया. What is your views? आप लोग इतने लोग यहाँ पर है. What is your views? क्या ये इजी है कि अगर वो गर्ल हमें रेप करने के लिए कह देती तो हम उसका रेप करते और उसके बाद उसको फेंक देते? क्या ऐसे पर्सन को हमको छोड़ देना चाहिए था? What happened in Calcutta? Everything is clear, and from so many days we are doing polygraphic test. And for a woman and for every person who is working in an organization, workplace is treated by him or her as an extended home. If he or she is not safe there, then इससे बुरा कुछ नहीं हो सकता कि वर्क प्लेस पे ऑफेंसेस हो रहे हैं. और from 1997 till 2013 and till 2024, we are not able to prevent these kind of harassment. This is all from my side. Thank you.
Thank you so much, ma'am, for sharing your extensive knowledge with us. As we conclude today's impactful and informative session on women and children, I would like to express our sincere gratitude to our distinguished guests, Professor Dr. Smita Nizar ma'am, Professor Dr. Namita Jain ma'am, and Dr. Shobna Jeet ma'am, for their outstanding guidance and commitment and their collective expertise and support that have been crucial in making this session a resounding success, ensuring that we address these critical topics with sensitivity and respect that they deserve. Your insights have deepened our understanding of the challenges faced by women and children and provided us with actionable strategies to drive positive change. I would also like to thank our participants for their engagement, focus, and shared passion in tackling these important issues. Before we conclude, please be reminded that our next technical session on senior citizens and persons with special needs will take place from 1 p.m. to 2 p.m. Additionally, please note that your attendance is being recorded. We greatly appreciate your coordination. Thank you.